So we have chapter review, real estate closings. You guys want to make some money? Let me see the show of hands. Yay! Yes, yes. This is the chapter, guys. This is the chapter. Okay, we need to know what the hell we're doing in the closing. Okay, hell yeah. All right. So now we're at closings. Okay. So now we're starting the review. It says that closings is the last step. We're not there yet because we're gonna see the timeline. There's an actual timeline that we go through next week. I'm gonna knock on metal here, okay? I'm closing on a deal. All right. So it's super exciting. Today I sent something that we called a commission bill, which means that we are gonna ask for our commission from the title company who's gonna cut us a check at the end of closing. So far, so good. I'm keeping my fingers crossed, okay? Because we don't close until the keys are given to the buyer, okay? So which means that all paperwork is signed and passed on to the buyer. So it says here, this is when they can't see you, Alexis. You can walk normal. 15 is not there. Here, there's a copy here. Bruno made copies. I'm sorry. I didn't put it there. Sorry. Lexus couldn't continue because she didn't have the chapter with her. Sorry. I mean, it's up here too. All right. A real estate agent's main relationship is with the buyer or the seller until the closing preparation starts. The closing or the contractual period. Okay. We call it contractual period. Appraisers, inspectors, loan officers, insurance agents, lawyers become part of it. So now I always say that at closing, we are going to have a party, okay? Because all the parties involved are the appraisers, the inspectors, loan officers, insurance agents, and lawyers. They all come to the party, right? And they all play their parts. Negotiations can go on. We're going to talk about that part, that section of the closing stage, often based on problems that are found during property inspections, sometimes until the property is fully transferred. The best way to keep a deal from falling through is to know the closing process inside and out. Believe me, if you're already stressed showing your client homes, the closing is one of the most fun, adrenaline, and stressful moments, not only for your buyer, but for yourself, okay? So we continue, says here, closing procedures. The point at which ownership of a property is transferred in exchange of payment of the purchase price is referred to as the closing. The closing consists of the buyer and seller verifying that each has fully fulfilled their respective obligations under the sales contract. So we talked about contracts and their provisions and their clauses and the timeline and how much money you put into the sale contract for the offer of the price of the house, okay? So now all those obligations of the sales contract are fulfilled. If they have, the mortgage loan is closed. Hallelujah. I don't know why, but every time I go at closing and I see something closed like that, I hear angels singing in the background. All right. All expenses are allocated and paid. The consideration for title is exchanged. Final documents are signed and arrangements are made to record the transaction in accordance with local laws. As previously stated, the closing process is based on the provisions of the sales contract. We talked about this, the provisions. So it is crucial that the parties take the negotiation for the purchase of the property very seriously during the offer and acceptance process. So there's a lot of things that you have to think about right before we go into the contractual process, right? The executory stage of the closing. So we have to really think about it. You could tell your buyer, listen, How much is this offer? And they're like, okay, if it's 400,000, I'm offering 410. How serious you are. But even before we ever get to the closing table, there's a conversation that you have to have with your buyer. And this conversation is about their finances, right? Because think about this. If somebody is getting pre-approved, we talked about this in the mortgage process, right? Originating a loan, and they get pre-approved, and now the underwriter continues to write out the loan, get the paperwork, get the information, and then finally have the loan ready for the buyer, okay? This buyer needs to know how much money they have to bring to the closing table, okay? A lot of the time, even for yourself, if this is the first time you take this course, oh, I'm sorry, just let me put the login real quick. For those of you who didn't log in, can you please log in now? Because I did go to the quiz and I promised to go back. Nika, let me know if you were able to sign in. Just give me a thumbs up. Okay. Oh, this is. All right, it doesn't matter. Whoever assigned this to this, today is the only chapter we're doing 15. My class in the morning did 14. So we could always change that morning to evening. So don't worry about it. So Steven, it says, please try again. Can you like sign in and sign out? Salvatore, if this is part of your class to get credit, please, you need to be on camera. I know Masha had a problem. Joshua, let me know if you're just here to study because I need you to have the camera on. Okay, so Stephen got to log in. All right, are we all good? Can I get a thumbs up? Elvis, if you're doing this class for credit, please turn on your camera. Connie says she'll be right back. Salvador. And I know the other, Joshua, are you here to study or are you here to take credit? Please put your camera on. All right, I'm gonna assume that we're all good to go, right? Okay, so, all right, Connie and Salvador. Please, Salvador or Salvatore, if you can please tell me you're studying or you're part of class, okay? Because if not, I have to tell Bruno, we cannot give you credit if you're not on. So if you're here, can you put your camera on? Okay, so Joshua says that he did it in the morning with me. Okay, I just gotta make sure. All right, so let me keep going here. All right, so it says here, many real estate professionals keep a list of events that must occur prior to the closing in order to avoid surprises that could cause delays. So I was talking about offer and acceptance and knowing right in the beginning where your client is, if they have the funds to buy a home, and if they're pre-qualified for a certain amount, then they have to have that money in the bank, okay? A lot of people don't know this because you guys are taking the course now, but we have something that is called the good faith deposit or an money earnest deposit. When the offer is being offered, we have a good earnest money deposit to say, hey, seller, I'm very serious about buying this property. Now, most of the times people would put $1,000. Nowadays, they put more than that. They could put 5,000, 10,000, 15,000, 20,000, or even 60,000 as earnest money deposit. What does this mean? That if you as the buyer don't go through with the sale of the purchase of the home, then the seller keeps that deposit. So I, as a seller, if I'm looking at the offers that are on the table, of course, I'm going to look at all the terms of the contract, but I'm definitely going to look at that earnest money deposit. How serious is this buyer in buying the house? Sometimes when you put an offer in and it's accepted, the realtor, the listing agent will call you, hey, I would like to see proof of funds. Your offer was accepted, but I would like to see proof of funds. So usually what I do is I'll call the loan officer and say, hello, I need you to talk to the other agent and let her know or he know that we're serious about buying this house, so that they can verify that that buyer has the funds and the loan is going to go through. Okay, I had to do it in this deal that I have now. And every time I put an offer in another property, we were always asked, do you have proof of funds? So now we have buyer concerns. Both the buyer and the buyer's lender must be confident that the seller will deliver the titled promise. In the purchase agreement, and the property is essentially the same condition as when the buyer and seller agreed to the sale. So they have to look at a home inspection, right? Look, buyer concerns. We'll notify the buyer of any issues that were not immediately apparent when the buyer viewed the property, as well as mechanical problems that an inspection may reveal. So this is very true. I just went through, I have 2 deals on the table. I went through inspections on these deals. And of course, one of the house, we knew that it was as is. So we knew that we were going to have problems with that property. And then the other one, it was in much better condition. So the one as is, the home inspections just help us see if there's any mechanical system problems and anything that the buyer should be concerned. So on this deal, the heater wasn't working properly. And the inspector said should be new one installed. And then there was problems with the sump pump. But that was little problems. There was problems with the roof because it needed to be reinforced. The columns, tiers, they needed to be reinforced. Then we had some cracking in the back. So I had little issues with the house, okay? Sometimes when the buyer sees an inspection, let me tell you, they'll freak out, okay? Because this is chapter 15, but I'll give you as an example. They'll see a report that is long, okay? The inspector report is like this, maybe 15 pages long, okay? Because guess what? The inspector is gonna cover his tushy, right? He doesn't want to get in trouble with the buyer, so he's gonna find every little thing that's wrong with the house, okay? But now your buyer might be freaking out. Oh my gosh, what am I gonna do this? How much is this gonna cost? So at this point, I had to get a contractor besides myself, an estimate, say, what are the costs to repair these things in the house? So we asked the seller for a credit. Hey, Mr. Seller, I know you said as is, but these are mechanical things and we really need to get them fixed. So they gave us a credit, okay? They gave us a credit. So now the purchase price of the home went down a little bit, okay? Instead of being, I'm gonna give you, for example, a number, 375, it went down to 370, okay? So here, we see that inspections are a big concern for buyers. Examining the results of an inspection, such as termite, yes, if there's termites, it feels like a nightmare. Radon, water and septic system, structural inspections and required repairs, the survey, the title evidence, including the seller's deed, and any documents demonstrating the removal or undesired liens and encumbrances, and any lease if a tenant resides on the premises, are thus among the buyer's concerns. So yes, the survey, okay? Somebody can be encroaching on the property that you're trying to buy. Who sends out for the survey? Who's responsible for the survey? While you think about that, Alexis, can you give me a little bit of water? Alexis is my assistant today. She's the only one here. So you guys are saying buyer. Anybody else? Who are supposed to get the survey? We got 28 people today. The buyer. I would like to see more answers. Thank you, Alexis. I appreciate it. Okay, buyer and realtor. Okay, anybody else? Yes, if the seller has it, they can provide it. But most of the time, the seller says that they don't have it. They've lost it. They don't know where they put it, right? So now the buyer's side, the attorney has to get someone, a surveyor, to go take a look at the property. All right, okay, Jefferson. So this is what happens. They get the survey. So if there's any problems with the lines, the boundaries, right? We talked about boundaries of the property, then the attorney has to take a look at that and try to, some type of mediation. The title evidence, okay? We have to make sure that the seller is who he says he is in selling the house. He owns the property, including the seller's deed and any documents demonstrating the removal of undesired liens. There might be liens or encumbrances on the property, right? And any lease if the tenant resides on the premises are thus among the buyer's concerns. A thorough inspection of the property by a professional home inspector who may be required by the state may reduce many of the buyer's concerns or identify issues that need to be addressed. Okay, so now we looked at buyer concerns. Now, final property inspection. Okay, in most real estate contracts, the buyer reserves the right to conduct a final inspection, also known as a walkthrough, shortly before the closing. Why do you think we do a walkthrough at the just before closing? Why do you think we do a walkthrough? What do you guys think? I'm gonna put my sound when I'm asking my own question. What do you guys think? So Masha puts, to make sure it's in the same condition as the last time we saw it. Shakira says to ensure no changes have occurred since signing. Connie says to make sure everything is still the same and no further problems. Lacey puts to make sure there is no new damage or anything that has been removed. To make sure it has, as you've seen it earlier, make sure the condition is the same as before to make sure there is still a property. And Lewis says what they said. Okay. All right, Lewis, I'll let you pass this one because it was a lot of wording there. But yes, you want to make sure that the crazy seller, right, didn't go crazy on the property. and started doing renovations or started taking things away from the property or damaged the property right before closing. Shortly before the closing, the buyer verifies, accompanied by a real estate professional, that all necessary repairs have been made, that the property has been well maintained, that all the fixtures are in place, and that no unauthorized removal or alteration of any part of the improvements has occurred. All right, Ashley. It is not the time to reopen negotiations, but rather to ensure that the property's condition complies with the terms of the contract. Now we're going to look at survey. Okay, what do we use a survey for in a real estate transaction? A survey provides information about the property's exact location and size. The survey typically indicates that location of the building, driveways, fences, and other improvements on the property. Any existing easements and encroachments should also be noted in the survey. The survey fee is negotiated in the sales contract. The survey is necessary to confirm the legal description of the property. Okay. All right, Nadia. Relying on an old survey is not a good idea. The property should be resurveyed prior to closing, even if the title company or the lender does not require it. A recent survey confirms that the property purchase is exactly what the buyer wants and that no encroachments have occurred since the last title transfer. And this is very true, because you know what? If you're not looking out for your neighbors, look, you know what they're doing. They could be encroaching on your property, right? Maybe you're renting that property as a multi-family and you're just collecting the rents. You have to go look at the property, make sure nobody's encroaching in there. Okay, so we have title evidence. The seller must provide evidence of marketable title, such as title insurance commitment to providing title insurance. Before making a title commitment, a title company conducts a title search. And we talked about this, right? To discover any liens, you see this on the state exam, encumbrances, restrictions, conditions, or easements attached to the title. We want a clean, nice, clean, marketable title. You know what I do when I want a clean title for my buyer? I put it in the washer. Make sure I put soap in there. And then when it comes out, it's nice and clean. I want to see the people that crack a smile are the people who are paying attention. Okay, I know my jokes are not that corny. All right, if there are any encumbrances or liens that affect the title, the seller is expected to remove them before the contract's deadline. An unpaid lien is the most common type of title cloud. Okay, can someone give me an example? If they find a lien right before closing, what's a typical example of a lien that hasn't been paid? What do you guys think? Good, Elizabeth. Yes, a tax lien, water lien, right? It might be that the seller forgot to pay. And it's strange because usually they do an auction to sell that tax debt to an investor, but it could come up that they haven't paid their taxes. Okay. I have someone I'm doing construction for, and we had talked about this with Stephen in the morning, and they were telling me that when the seller was selling the house and at the closing table, he owed $5,000 on water. Who in the world, you know, how in the world, first of all, the town of, I'm going to say Kearney would allow that to happen, but the seller owned $5,000 in water. So they had to take it out of the, you know, the net of the sale of the house to pay that. The seller may also be asked to sign an affidavit of title stating stating that no new liens, judgments, unpaid bills for repairs or improvements, unrecorded deeds or contracts, bankruptcies or divorces that would affect title, or any other defects the seller is aware of have occurred since the date of the original title search. Okay. If the seller's mortgage liens are to be satisfied at closing, so now we're looking at the mortgage lien, right? Is the mortgage the loan? What do you guys think? Is the mortgage the loan? Put it in the chat for me. So Masha says yes. Masha, were you here yesterday? Okay. Katie Lee says yes. Anybody else? Guys, I explained this last time. For those of you who weren't here last time, we have the house, we have the lender, we have the promissory note, IOU, okay? So the mortgage is what to the house? Can someone tell me? What is a mortgage? So Zoraida says it's a lien. Yes, is a lien. What happened to my pen? It won't write? What happened? Oh my God. I wasn't even pressing that hard. I might be in trouble. I think I broke the pen. Okay. All right, just make believe it goes away. Okay. Hold on, let me see. I'm gonna have to get out of the chapter and come back in to see if it works. Oh, the tablet is frozen. Oh, phew. I almost thought the pen was frozen. I mean, the pen was broken. Hold on a second. Technical difficulties. All right. Hopefully Bruno will respond. Oh, after I told him, it started working. Okay, that's spooky. All right, hopefully he won't be here. Let me put never mind. Hold on. Okay, hopefully he doesn't come. Okay. So now we said it's a lien. Okay. Now the mortgage is a lien that liens on the house as what? If you guys remember. Yes, collateral. To who? To who is it collateral? No, not the buyer. Yes. So the lender, right? We don't say bank because it could be any lending institution. So the bank is giving them the loan, okay, to the buyer. All right. And it says, wait up a second. You can't sell the house without satisfying the loan. Okay. So you have a lien on the mortgage. I mean, a lien mortgage on the house, which means that even if the seller wanted to sell, they can't because they have a lien. They have to satisfy that lien first. So we said that if they want to sell, the lender does an acceleration to ask the seller to pay before they sell the house, okay? So the mortgage is not a loan. It is a lien, okay? Now we have, let me go back. So everybody got that? The mortgage is not a loan? All right. All right. Mortgage liens are to be satisfied at closing. The lender will provide a payoff statement, also known as the offset statement, indicating the amount of unpaid principal and interest due as of the closing date, as well as any fees owed to the lender and any credits or penalties that may apply. A similar statement, known as the beneficiary statement, will be provided by the holder of a note secured by a trust deed to show unpaid balance. Even if the buyer assumes the seller's mortgage loan, the buyer will want to know the exact amount owed at closing date. Now, we're also going to look at buyer's concerns, okay? It says, the seller primary concern is receiving payment for the property. So the seller will want assurance the buyer has obtained the necessary financing and will have the funds to complete the sale. Like I was telling you before, this is usually when we're already under contract, right? But nowadays, they want to even know it when you're just submitting the offer. In return, the seller may have a list of tasks that must be completed in accordance with the purchase agreement. Unless the seller owns the property free and clear of the mortgage debt, there must also be a payoff statement from the seller's lender, indicating the amount owed and which will be paid from the sale proceeds. Both parties will want to inspect the disclosure statement made prior to closing with their attorneys or real estate professionals to ensure that all monies involved in the transaction have been properly accounted for. So the seller needs to show whether they paid off the loan, right, prior to selling, or that they have an unpaid debt to the lender that will have to be satisfied at closing. Now we look at role of a real estate agent at closing. So what is your role? Okay. Depending on local custom, the role of the real estate professional at closing can range from simply collecting the commission to overseeing the proceedings. In states that require the participation of an attorney, a real estate professional responsibility ends when the real estate contract is signed. And agents take this literally, okay? But what happens? Most real estate professionals remained involved all the way through the closing on behalf of the clients because it's also in the best interest of the real estate professional that the transaction concludes successfully and smoothly. So what does this mean? Once the offer is submitted, okay, and accepted by the other party, the selling party, then you are on the period of attorney review, okay? So they're negotiating the contract. The attorney review can continue, but they usually have 3 days to withdraw from attorney review. We also call this the cooling period, okay? So within those 3 days, you can say, you know what? I made a mistake. I don't want this house anymore, okay? And you can back out of it. But then after those 3 days, you're in already under contract, even though we still have attorney review. We're still negotiating, okay? So what happens? Your buyer is so used to working with you that now you tell them, okay, now everything goes to the attorney. I'm kind of hand you off to the attorney. You'll be in good hands. They don't hear that. All they hear is, wah, 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 wah. You're going to keep helping me. Okay. So then you're like, oh, okay, I'm stuck with this person, right? No, they're sweet. Usually your clients ends up being really close to you. And then what happens? They're like, Jen, what's going to happen after this? You know, I see the attorney is doing this and that, and I have to go and explain to them what the attorney is doing, what they're going to order. Now I said to them, so now we're under contract. All parties are agreed to the terms. Now we're going to look into inspections. Oh, but what are inspections? Do you think they'll find something wrong with the house? Listen, I don't know. We have to get the inspector out there. Most of the time, you have to pay for the inspection, okay? And then it depends on the inspector. These inspectors sometimes charge between $450 to $600 for that inspection. So they will inspect the whole house. They might even do radon, and they'll do the sewage line sweep to see if there's something wrong with the water lines that are from the house all the way to the sewer. Okay, I always recommend that because we've had too many problems with storms and backups. You remember last year when we had that huge storm, most of the people in Elizabeth were almost wiped out. There was like people were surfing in the waters in Elizabeth. I was like, oh my gosh. So anyways, it's just a joke. I know some people, poor people, some people had a mess. We even had agents that live in Elizabeth deal with water all the way in their basement up to their hips. So they were dealing with a lot. So then they're going to ask you these questions. So you have to tell them this is what it means. They're going to look at the sewer line, see if it's clean, if there's any backup that you might have that might be coming back into the house. Okay. So now one of the deals that I have, the sewer line is not, they don't have a clearance. So it's not coming also from the house to the pipes. It's going directly because the houses are attached. So it's going directly from the pipes to the sewer. So in that case, it's very hard for the inspector to put the machine through the clearance to see the pipes. So what he was telling me in this situation is that if the homeowners wanted, they would have to run a line from the pipe to their house or their garage so they could see the clearing. Of course, I don't know how much that is, but that was an option. Okay. Radon. Radon is odorless. Okay. You cannot smell it, but if you have radon in your house, you can have cancer. You can get cancer from radon. So what happens is that they have to come and put a test. Okay. And you can't be opening doors. If it's in the basement, it has to be closed until 4 days after the test so that the inspector can come and take a look to see if there's radon, high levels of radon in the basement. Usually it's 4C, I think it is above 4C. And so they have to inspect that. Have you ever heard of a tank sweep? Yes, no, maybe so. So some people say yes. So a tank sweep is they come and they take a look if there was an oil tank in there and if there's any residue or anything that is hidden underground, okay? Some of the associates here said that they found a car buried underground, a refrigerator, a washer. Guess what? Because they didn't want to put it and get it thrown away. I don't know, people can be crazy. They might bury something or a pool or metal. Nadia says a body. Nadia, what have you been doing? Okay. Those kind of crazy thoughts don't bring them to real estate, all right? She's like, I don't know. You know what? That is true. I don't know. In Newark, I'm getting a little bit outside of real estate here, but there was in the newspaper on TV that there was a body that was buried under a house. It was a doctor. He practiced plastic surgery. He wasn't board certified. He didn't have his doctor's degree, but women came to him so that he could do plastic surgery. So one of the plastic surgeries went bad, okay? And so what happened was that the doctor buried the body under the house, okay? And they couldn't find the body for a long time until they finally found the body and prosecuted that fake doctor. Now, how did I know this? I have a friend who's a mechanic, and he's like, bring your car to my house. I'm gonna fix it, okay? So while we were talking, he was telling me about his neighbor and how they had buried a body in there. And I was like, okay, so whatever was on TV was the body that was buried there. Of course, they took the body out already, but I get to see the house and where it was, the body was put in, okay? So yes, weird stuff happens. Thank you, Nadia, for bringing that up. You go, girl. All right, so now we have here somebody put, radon's a type of gas that's basically poisonous to humans. Yes. So you have to, they come and if they find high levels of radon, usually out west in New Jersey, not Pennsylvania, west New Jersey, you have higher, west north, higher radon levels. So they're always testing Sussex County, up there, Warren County, because it's very, very common, okay? So Stephen says, East New York, every empty lot you put a shovel in would turn up. Oh my gosh. Yeah, people, listen, maybe they have to pay to get that garbage thrown out. So they'll rather bury it in the backyard or the front yard. I know, that's crazy. All right, so let me continue here. It says, nonetheless, Stephen says, oh, you meant a body? Well, that's New York. You know, New York people are a little, New York and New Jersey don't get along. So yeah, you can find a lot of stuff in New York City or New York. All right, nonetheless, the most real estate professionals remained involved all the way through the closing on behalf of their clients because it is also in the best interest of the real estate professional that the transaction concludes successfully and smoothly. Let me tell you, it's never a smooth ride, okay? That's only in theory. You're gonna sweat. This could include actively arranging for title evidence, surveys, appraisals, and inspections of repairs or structural conditions, water supplies, sewage facilities, or toxic substance. Although real estate professionals do not always conduct closings, they are usually present during what can be a stressful experience. The parties frequently look to their real estate professionals for guidance, assistance, and information. So yes, we have to look at our broker. We have to tell him, listen, well, mine is Pedro. Pedro, I have this deal. What do you think? He's looking at the contract. He's looking at the provisions. He's telling me, he's guiding me. Even though I already know most of the time what to do, I want to make sure that my broker is well informed. Why? Because we said before, if they're not well informed and you do something wrong, and then your license is suspended, guess what? Your broker's license may be suspended also. Okay, I'm sorry, just give me a second. So that's one thing, you always have to have your broker involved. Real estate professionals be completely familiar with the procedures, okay? In preparing the disclosed statement prior to closing, including the prorations of closing costs, which will be discussed later. Most of the time, this is part of the mortgage or the title company, not so much on the real estate agents. The real estate agent should never discourage the seller or buyer from using an attorney before closing. Now, if you see in the contract, let me see if I can go to the contract really quick. I'm gonna go here. This is a third-party software that I use, but I'm gonna show you the contract or a little bit of it. An offer that we submitted that wasn't accepted. Okay. So now we have this property, they never accepted our offer, okay? So we're gonna go here. These are the documents that you might have to, that you might see that you have to add to your offer. So you have the addendum coronavirus, real estate sales contract, the CIS, and we'll talk about this, and the exclusive buyer agency agreement. Okay, right here. Notice to buyer and seller. So this is why it says never discourage the seller or buyer to get an attorney at closing. The law requires real estate brokers to give the following information before you sign the contract. It requires us to tell you that you must read all of it before you sign. The purpose is to help you in this purchase or sale. Okay. right here. A buyer without an attorney or a lawyer runs a special risk. Only an attorney can advise a buyer about what to do if problems arise concerning the purchase of the property. The problems may be about the seller's title, the size and the shape of the property, or other matters that may affect the value of the property. If either the broker or the title company knows about the problems, they should tell you, but they may not recognize the problems, see it from your own point of view, or know what to do. Originally, the broker and the title company have an interest in seeing that the sale is complete, because only then do they usually receive their commissions. So their interest may differ from yours. So that's what they're telling you. They're telling the buyer that they should get an attorney. That's why you can't discourage your buyer from getting an attorney, okay? Because it's letting know the buyer that it is in the broker's interest and title company that you close, okay? All right. So real estate agents should never discourage the seller or buyer from using an attorney before at closing. Even in states where it's mandatory, the license should in fact offer advice on the significance of choosing a qualified seasoned real estate attorney. So we always say this, you need to get an attorney who specializes in real estate, right? When you become an attorney, you can do law anywhere. But the more specialized you are, the more you are at best with dealing with problems within real estate, okay? I know you guys have attorneys who have already taken you out of jail, okay? Not those, all right? The ones that specialize in real estate. All right, closing requirement. Yes. What about the attorney, lawyer's pay? Yes, so the buyer pays the attorney and they hold a little bit of money, okay? And they said that even if the deal doesn't go through, the buyer has to pay the attorney for the work that they've done. It's almost like the inspector. They've done work, they got to get paid, okay? So it will be prorated on the amount of work, but they have an agreement that they'll send to the buyer, signing and letting them know if the deal falls through, they still own the attorney for work and service being done. So Elvis puts, what if, okay, so I answered that. Does somebody have anything else? Okay, Milton, so you couldn't check in? All right, I will tell Bruno. All right, lender's closing requirements. A lender is concerned about the quality of the collateral provided or borrower in exchange for a mortgage loan. Defects in the title, liens that take precedence over the mortgage lien, such as a tax lien, a physical damage to the property that's not repaired, would jeopardize the collateral. As a result, the lender typically requires a survey, a property inspection, hazard insurance, title insurance policy, a tax and insurance reserved accounts, and possibly private mortgage insurance. And we kind of talked about this already about the lender in chapter 13 and 14. In some cases, a lender also requires a certificate of occupancy to ensure that a new construction performed is in accordance with local building codes. And this is very, very typical. And it's within every town. We call this a CO, certificate of occupancy. So the inspector of the town comes to see the home and see if there's smoke detectors, there's a fire extinguisher, if there's any gas that is leaking out of the house, okay, that it hasn't been detected before. And they check that everything is clean and that people can live there, okay? But you have to get it, usually it's towards the end that they get it, so that way that they can move into the house. So if you're the listing agent of the property, guess what? You have to go and get the certificate of occupancy. And what happens when you go to town? You will talk to someone that says, okay, let's see if there's any permits open, okay? Because it could have been that they made a deck or they made a new bathroom and they didn't close out the permits. So that will show there too. So it says IRS reporting requirements. The Tax Reform Act of 1986 requires real estate brokers to report a closed real estate transaction to the Internal Revenue Service and to provide the information contained in the report to each party to the transaction. The term real estate broker is defined in the act as any of the following: a seller's broker, a buyer's broker, the settlement agent, real estate agent, attorney, title company, or other party responsible for the closing the transaction, or the mortgage lender. Anyone so assigned by the IRS. The reporting person submits a Form 1099-S information returned to the Internal Revenue Service that includes the names and the address of the transaction parties, as well as the information about the sale proceeds. The reporting person also provides each party to the transaction with a written statement that includes the reporting party's name, address, as well as information reported in the 1099. All right, so now we come to conducting the closing. Just give me a second. What page are we on? 179. I want to see how long this chapter is before we go to break. Oh, yes, we have the closing CD. Okay. Oh, it is a lot of pages. All right. Ooh, 25 pages. I guess there's no break. So, sorry, guys, no break. We'll go 1 minute, take a breather, and go back. All right. I might go a little fast. Yeah, exactly. Shoot me now. All right. All right. So let's continue here. For example, closing is referred to as settlement or transfer. The closing process can also take various forms depending on state law, local custom, or parties' convenience. Passing papers, that's what we do. We're signing papers and paperwork, and the attorney, what he's doing at the closing table is signing paperwork that the buyer will get at the end and checking to see if everything is correct, in which the parties to a transaction sit around a table and exchange copies of documents as they are executed. In other areas, buyer and seller never met. So usually the seller doesn't come to the closing because they're done. They already did what they had to do. They don't have to sign any paperwork. So they're not going to show up. Years ago, both of them would show up. Okay. The paperwork is handled by an escrow agent during the closing escrow process. And we said that the escrow agent can be the title company. The primary concerns are that the buyer receives marketable title and that the seller receives the purchase price. Okay. Face-to-face closing. A face-to-face closing can happen at the office of the title company, the lending institution, an attorney for one of the parties, the real estate agent, and the county recorder as the escrow company. Okay. And I wanted to, I guess we don't have a timeline here, so I'm going to go and show you the timeline. So when you are offering, doing an offer in a house, you have the pre-offering stage. Okay. Once offer is accepted from both parties and the terms are agreed on, we are in attorney review. Okay, we're in attorney review. Then in this period here, right, those are the terms. We're hoping that each side is okay with everything. And now here, we are under contract. Okay. Can someone tell me what this period here is? If they remember. What is that period? Quick, guys, because I don't have a lot of time. Come on, you guys know this. Come on, you do. Come on. Yes, thank you, Masha. Executory period. Yeah, she's here. But we can't see her because she's having problems with her camera. So once that period is over, what is this called here? Executed. It's okay if you say it. I'm not going to hurt you. executed. Now, within this executory period, we have inspections, right? And here in this period, we're gonna ask the seller to make some repairs to the property, okay? Or try to get a credit for those repairs. Then after some time, we're also going to get an appraisal for the property, okay? Once the appraiser says, hey, you know what? The house appraised for what it's offered, we can continue. This isn't a perfect world, okay? So that now here, we're waiting for the loan company, right, and the title company to do their thing. And we have the lender giving an loan estimate. They're having to do the commitment of the loan after they see over here the CD, the closing disclosure. So all this is happening in this period of time, so that we can finally get to the closing table and have the contract executed, okay? So that's how it goes. All right, face-to-face closing, we did closing agent, sorry about that, or officer. The closing agent could be a person from the title company or the lender, real estate agent working for one of the parties, or the buyer's or seller's lawyer. Some law firms and title companies hire paralegal assistants to help with closing. The closing agent orders and looks over the title insurance policy. Remember we talked about that? The title certificate, survey, property insurance policy, and other items. After the sales contract is looked over, a disclosure statement is made that shows how the income and costs are split between the parties. At this point, the closing time and place are set. Conveyance, what did we say conveyance was? Masha, I'm sorry. You definitely, for not being here yesterday, are not gonna get a break. So transfer, yes. Says when both parties are satisfied that everyone is in order, the transaction is completed. The seller delivers the signed deed to the buyer. Oh, sad face. It's okay. You're a grown girl. You'll to ensure title continuity. All relevant documents are then recorded in the correct order. For example, if the seller pays off the existing loan and the buyer obtains a new loan, the seller's mortgage satisfaction must be recorded before the seller's deed to the buyer, because the buyer cannot pledge the property as security for the new loan until ownership is transferred. The new buyer mortgage or deed of trust is not recorded until the seller's deed to the buyer is. Okay. Now we have closing and escrow. Okay. Just want to see something really quick. All right, I want you to show you really quick the closing disclosure, okay, and the loan estimate. This one right here is the loan estimate. This is what your buyer will get 3 days after the loan process application, okay? And now in chapter 15, I want to go over this a little bit. It's going to be this very close to the CD. So we said we put the date, the applicant's name and where they live, the property address, and the sales price of the property. We also talk about the long terms, 30 years. And its purchase. Is it a fixed rate? Yes, it is. Now we also look at the loan type. Is it a conventional, FHA, VA, or other? So right here it says it's conventional, okay? Loan ID, rates locked, yes. So this is very important because it will tell us, let's say they lock the rates, here it is, at 3.875. You have a period of time to honor that rate. It says before closing, your interest rate, points, and lender credits can change unless you lock that interest rate. All other estimated closing costs expired on this day. Remember, we talked about expiration at 5 p.m. Okay, so here we see the loan amount for the buyer. Can this amount increase after the closing? It says no. Interest rate, can it increase after the closing? No. Monthly principal and interest, this is how much they will pay before taxes and insurance, and it will not increase. So it just says, does the loan have these features? It says prepayment penalty. I talked to you about this before. It will tell you if you will get a prepayment penalty if you pay off the loan before the due date. Okay, so it says as high as $3,240 if you pay off the loan during the first 2 years. So it also has a balloon payment? No. Projection calculations. Okay, so it says that in this calculation, principal and interest is $761.78 for the first 1 to 7 years and from years 8 to 30. Now, mortgage insurance. The mortgage insurance MIP is $82. But after 8 years, they don't have to pay that PMI. It says estimated escrow amount can increase over time. So we have an escrow account for $206 for the first 7 years, and years 8 through 30 the same. But it says here, it could vary, it could increase because taxes increase. Estimated total monthly payment. Now we're looking at the estimated total monthly payment of $1,050 for the first 1 to 7 years and $968 for the 8 to 30 years. Estimated taxes, insurance, and assessment. So we have taxes, insurance, and assessment for $206 a month. So it says this estimate includes property taxes, yes. Homeowners insurance, yes, and that's what they will be paid. Cost at closing, estimated close at closing. So we have $8,054, which includes $5,672 in loan costs, plus $2,382 in other costs. In lender credit, see page 2 for details. Estimated cash to close. So they have to bring to the table $16,054, okay? Including included closing costs, calculated cash to close in page 2. Closing cost details. So now you see here, they charge you for originating the loan. It's at $1,082. 0.25% of the loan amount, 405, application fee and underwriter fee. So you have $1,097. Then we can look at other costs. Taxes and other government fees, recording fees and other taxes, transfer fees. Prepaids, homeowners insurance premium, 6 months, $605. Mortgage insurance payment premium, they don't show anything. Prepaid interest, $17.44 per day for 15 days at 3.875 gives us $262. Prepaids and property taxes. Okay, we continue. Services you cannot shop for: appraisal fee, credit report fee, flood determination fee, flood monitoring fee, tax monitoring fee, and tax status research fee. So only the lender provides this information, but you still have to pay for these fees. Initial escrow payment at closing, $413. Homeowners insurance, $183. Mortgage insurance, none. And property taxes, $211. We also have other. Title ownership, title policy, optional. If the buyer wants a title policy for the lifetime of the loan, they only pay $1,017. So it also says here, services you can shop for. This is you. Pest inspection fee, survey fee, title insurance binder, title lender's title policy, title settlement agent fee, and title search. We also have other total other costs. So here it totals to $2,382. Totaling costs, closing costs here, adding D and I. So we have D and I. Oh, so you add up the other ones too, but this is for this one. D and I, you get 8,054. And then, so now we do the calculation to close. Total closing costs, 8,054. Closing costs, finance paid from the loan amount, 0. Down payment funds from borrower, 18,000. Deposit, so there was a deposit, we're gonna subtract that, minus 10,000. Funds for borrower, funds for, seller credits and adjustments and other credits, and the total estimated cash to close. Do we bring cash to the table? Do we get a suitcase and we open it up and there's all that cash in there to the table when we go to closing? It only happens in movies, guys, okay? So no, we bring a certified check from the bank. Masha says, duh. Guess what? When we started, there was a couple of women we started together, and I remember one of them had her first buyer before we still even had a buyer. And she calls me and she said, no, and I started having a buyer. She goes, Jen, it says cash to close. Do I have to bring money? I said, no. I said, all you have to do is bring a certified check. It's funny, but sometimes, when you read something literally, you assume that is what it is. So it is a certified check of 16,054. And I'm going over this because now I'm going to go and read back what I didn't read, but it's going to make more sense. Okay, so additional information about this loan. The lender is FICO's Bank, loan officer Joe Smith, NJMLS license ID, email, and phone number. Okay, and now it says comparison. Use these measures to compare the loan with other loans. So in 5 years, 56,582 total will have paid in principal, interest, mortgage insurance, and loan costs. 15,773 is in principal, you will have paid off. So remember, always in the beginning, we're paying the lender more money than we're paying the principal. Now, we also talked about the annual percentage rate, right? These are the rates plus the fees from the bank, the lender. So if we look up here really quick, we see that the interest rate is 33.875 compared to the annual APR at 4.274. So there's a difference there because the fees are included from the lender. Total interest percentage tip, 69.45%, the total amount interest that you will pay over the long term as a percentage of your loan amount. So now we also have other considerations, appraisal. We may order an appraisal to determine the property's value and charge you for this appraisal. We will probably give you a copy of any appraisal. So the buyer pays for the appraisal. Even if your loan does not close, you can pay for an additional appraisal for your own use at your own cost. Assumption, if you sell or transfer this property to another person, and it says, will not allow assumption for this loan on the original terms. Homeowners insurance. This loan requires homeowners insurance on the property, which you may obtain from a company of your choice that we find acceptable. Late payments. If your payment is more than 15 days late, you will charge you a late fee of 5% of the monthly principal and interest payment. Refinancing. So look at all these terms. This loan will depend on your future financial situation, the property value and market conditions. You may not be able to refinance this loan. We intend servicing to service your loan if you will make your payments to us or to transfer servicing of your loan. So you can do that. All right. And then confirm receipt, they have to sign. And that is the loan estimate. Now, it differs a little bit from the closing disclosure. Okay. We said that it can't be a big disparity between numbers. But now we see more actual accurate numbers compared to the ones we saw before. So now we said that it was around how much? 16,054 for closing costs, cash to close. So in a CD, we see here, oh, now this too, I'll show you this. It shows you a little bit different, but where is the, I was looking for, where is the closing, cash to close? So right here, cash to close, 14,147.26. As you can see, is not very different than the loan estimate, okay? Now, the CD does include a lot more fees for you to see than the actual loan estimate. So we talked about, this kind of is the same as the first one, okay? The first 7 years and then the 8 to 30 years and the amount, the escrow collection, the monthly payment, estimated taxes and insurance. Assessment could have gone up a little bit. In the escrow, you have property taxes, homeowners insurance, and other homeowners associations to know. So closing costs, it was a little higher than the estimated loan. And so we have here 9,712 and cash to close 14,147.26. So now to get to this, again, we have to look at this, the closing details. So again, it talks about origination charges. Borrower paid. This is the borrower. And this is the seller. Okay. So now we have the loan amount, application fee, and underwriting. Servicers borrowed did not shop for, so the lender shopped for the borrower. Appraisal fee, credit report fee, flood determination fee, flood monitoring, tax monitoring fee. Can you guys see this better? Okay, so it says services did not shop for, so we see there, this is what the seller had to do and didn't shop for, but it was sent by the lender. So maybe it probably is the appraisal fee. So here we have, hold on a second, let me see what's the row. Okay, so at closing and before closing. So this is at closing and this is before closing. Okay, that column. So now we have here, it says loan total cost at A, B, and C. And this is what you get, 4,694. Taxes and other government fees, prepaid, initial escrow payment at closing. So you see here you have also HOA, if it's a condominium, right? Processing fee, inspection fee, warranty fee, real estate commission, and so on and so on. And that totals to 5,018. Total cost, 9,712. Now here, talked about that already. We saw the seller transaction. So it says due from borrower at closing, 189,762.30. Seller's transaction, due to seller at closing, $180,080.00. So now we say the sales price was this, 180,000. Sales price for the property, 180,000. And so on. Closing paid at closing, 9,682. The seller doesn't have much because it's the buyer's loan. So now we look at adjustments for paid by seller in advance and dates due for the HOAs, $80. It says paid already by or on behalf of the borrower at closing. Okay, so 175,615 is the payment that is made from the borrower at closing to the seller. And then so on and so on. And then we have cash to close for the buyer and how much, okay? Because probably the seller owes the bank on the loan, right? And then this is how much they will make, right? 74,414.96. This will be the net for the seller. Okay. So you could also read that on your own. Let me go back. Are you guys understanding? Is it better this way? Okay. So let me go back to what I didn't read. And in 10 minutes, we'll have a break just because Masha can't take it. She can't live without a break. Okay. Masha, you get 2 minutes. All right. Okay. Let me go back. So we kind of brushed upon this on chapter 14. So I'm going to go quickly. It says closing in escrow. If the escrow takes place in escrow rather than in person, the principal party deposit funds and documents with the appointed escrow agent, and the escrow agent disperses funds and releases documents to the appropriate parties when all escrow conditions are met. If the transaction cannot be completed for any reason, for example, if the buyer refuses the title as its offer or fails to produce the required cash, the escrow instructions usually include a mechanism for returning title to the seller and funds to the buyer. In this case, both parties revert to their original position of sale had never occurred. Federal closing laws and procedures. So now we have, again, revisited Real Estate Settlements Procedures Act, which is RESPA. It is federal law that requires certain mortgages and settlement process disclosures and prohibits certain practices that raise the cost of settlement services, such as kickbacks and referral fees. The Mortgage Disclosure Improvement Act has altered the way buyers, sellers, and lenders, mortgage brokers, title agents, and other real estate professionals prepare for closing. To implement provisions of the Dodd-Frank Act intended to combine and clarify financing disclosures to consumers, the Consumer Financial Protection Bureau issued the TILA-RESPA Integrated Disclosure TRID. This rule is applicable to transactions that occur on October 3rd, 2015. So here, that's why we get the CD, to see all the breakdowns of the fees that we have to pay. Real Estate Settlement Procedures Act, the Real Estate Settlement Procedures Act is an act in 1974, consumer protection law. It allows, its goal is to simplify settlement costs and eliminate kickbacks and fees that raise settlement costs. RESPA requires certain closing procedures when a purchase involves a residential property, including 1 to 4 families, residencies, cooperatives, and condominiums, a first or second mortgage lien, and is financed by federally related mortgage loan, which includes loans made by federally insured lender, loans insured or guaranteed by VA, FHA, loans administered by HUD, and loans intended to be sold on the secondary market. So it's definitely only for VA and FHA loans. RESPA, what does RESPA do? Regulates do not apply to transactions that are otherwise financed unless the terms of the assumed loans are modified of the lender's charges for the assumption exceed 50. You're not going to be tested on that. RESPA is aimed at lenders and settlement companies, but licensees should be aware of the requirements and changes that went into effect on January 2014. The Dodd-Frank Act of 2010 gave the Consumer Financial Protection Bureau rulemaking authority under RESPA, as well as general authority to supervise and enforce compliance with RESPA and its implementing regulations, okay? The CFPB made substantive and technical changes to existing regulations in 2013. This is also telling you that there has been a lot of regulation that has been going on because, like I said before, people were taking advantage. Modifying the servicing transfer notice requirements and implementing new procedures and notice requirements related to borrower's error resolution and information requests were among the significant changes. New provisions were added concerning escrow payments, forced placed insurance, general servicing policies, procedures, requirements, early intervention, and continuity of contact, loss mitigation, and the relationship with RESPA servicing provisions to state law. The RESPA amendments became effective on January 10th, 2014. So provisions under RESPA, okay? Here, very important. RESPA prohibits certain practices that raise the cost of settlement services. This is what we're trying to keep low, the cost. Section 8 prohibits kickbacks and fee splitting for settlement service referrals, as well as unearned fees for services not actually performed. Violators face both criminal and civil penalties, including a $10,000 fine and or a year in prison. The consumer may pursue a violator in court privately. The violator may be liable for up to 3 times the amount paid for the service. Section 9 forbids a home seller from requiring the buyer to purchase title insurance from a specific company. For such a violation, the buyer may sue the seller. The violator is liable for up to 3 times the amount paid for the insurance. So things like this, you will see on the state exam, okay? Section 10 makes it illegal for the lender to require excessive escrow account deposits for items such as taxes and hazard insurance. So an escrow account can say, put $30,000 in escrow for taxes and fees. They cannot do that. They will only take the amount they need. Now, if anything goes up like taxes at the end of the year, they have to ask for more money because escrow is negative. Affiliated business arrangement, ABA. A real estate firm, title insurance company or mortgage broker, home insurance company, or even a moving company may agree to offer a package of services to consumers in order to streamline the settlement process. A system known as affiliate business arrangement when there is 1% or more common ownership between the companies. RESPA allows an ABA as long as the consumer is clearly informed of the relationship among the service providers. Participation is not required. Other providers are available, and the only thing of value received from the arrangement, in addition to permitted payments for services provided, is a return on the ownership interest. Fees must be reasonable in relation to the value of the service provided and cannot be exchanged between affiliate companies solely for referring business to one another. Okay? All right, it's 7:27. We've got 3 more minutes. I'm getting ready. All right, TILA RESPA integrated disclosure rule. TRID replaces 2 new disclosures forms for 4 previous disclosure forms. So the new disclosure, loan estimate and closing disclosure, created these forms to help consumers understand the cost of closing for transactions that began on or after October 3rd, 2015. New forms are required. The forms apply to most consumer mortgage transactions except for home equity lines of credit, reverse mortgages, and mortgages secured by a mobile home or a dwelling that is not attached to land. The forms are also inapplicable to creditors who make 5 or fewer mortgages a year. Although the lender bears the burden on implementing these forms, real estate professionals should be aware of current requirements because failure to meet the standards can and will delay the closings. So this is what I said before, you have to understand well the closing disclosure and the loan estimate. We call it LE. Form takes the place of initial true in lending statement and good faith statement. This form emphasizes the information that has historically been important to consumers. On the first page, the interest rate, monthly payment, closing costs are predominantly displayed. 3 business days after submitting a loan application to the lender, the consumer must receive the loan estimate form. The loan estimate must include the exact language specified the CFB, allowing borrowers to compare loan conditions from one lender to another. The fee for a credit report is the only fee that the lender may collect before the loan applicant receives the loan estimate. So your buyer, okay, to pause there for a moment, your buyer can make 3 different applications with the 3 different loan companies to see which one is best. This is state law. They are allowed to do that. Even though you love working with your loan officer, they are entitled to get 3 different applications. Loan estimate. Once the loan estimate is issued, the lender is committed to making the loan on the specified and may only charge the loan estimate in limited circumstances. A new loan estimate must be issued if certain information or circumstances changes after the loan estimate is issued. Some closing costs or fees may change before settlement. One of the transactions that I was in, that I was helping my first buyer, she got the loan estimate and she went through all the numbers, but then when she got the CD, some of the numbers were off. So we're at the closing table and the attorney says, well, you know what? We can send this back to title and wait a few more days. And I was like, oh my gosh, we're at the closing table right now. Like I'm waiting for my commission check, okay? Now this is the time to be excited about my commission check. And now we have to send this back to title and reschedule the closing. And then the attorney said, okay, hold on, wait, let's call the title company and see that they fix these numbers and send us a new CD. So this is where it talks about if there's any changes or circumstances, it can change after the original loan estimate is issued. Some closing costs or fees may change before settlements. So even at the closing table, they were changing some of the CD fees and correcting some errors. The fees are classified into three different types. Okay, let me see where we are. Okay, I'm gonna go to the end of the page and then we'll go into break. The fees are classified in three types. No tolerance, fees that may not increase prior to closing, like lender charges for taking, underwriting, and processing the loan application, including points, origination fee, and yield spread premium. 10% tolerance, fees that cannot be increased by more than 10% in any given category, such as settlement services for which the lender selects the provider or for which the borrower selects the provider from the lender's list. Title services and tied insurance if the lender selects the provider, and recording fees are all examples of fees that may be charged. Unlimited tolerance, fees for services over which the lender has no control, for example, escrow and title insurance, as well as impounds or escrows for taxes, mortgage interest, and the cost of homeowners insurance. The final page of the loan estimate is a summary of the loan terms that the customer, can use to compare different loans and terms to save money when shopping for a loan. The lender is responsible for the loan estimate accuracy, as well as the structure costs charged by the lender, which are shown on the closing disclosure form. Okay,